Good evening. I'm Avital Levin, a social worker and the Director of Education at Shalom Task Force. In the past 24 hours, I have had the following kinds of conversations. One, with a high school principal supporting 2 students. The level of abuse and family violence in these homes spiraled, and they were kicked out by their parents. 2, with a single mother who is working around the clock, terrified of losing her job. She's quarantined in a tiny basement apartment with her 3-year-old. Her ex-husband has been refusing to see their child, and she has no access to child care providers. This leaves her with no reprieve, feeling totally isolated and helpless. 3, with a woman who has endured years of horrific abuse by her husband and is now trapped in a confined space, with stressors mounting and their children witnessing each encounter. We typically associate home with comfort and quarantine with safety from outside elements. In each of these situations, home represents a lack of safety and well-being. For over 25 years, Shalom Task Force has been at the forefront of supporting victims of abuse. At this time of global crisis, we are working to provide critical support through our hotline, education, and legal departments. We bring you tonight's program to provide practical guidance from our legal department, Sarah's Voice, which provides free services for victims and survivors of domestic abuse. We have invited a number of organizations and agencies as co-sponsors of this program. Achieve Behavioral Health, Adead, Amudim, Extended Family, MASK, Met Council, ORA, the OU, Project Sarah, Sister to Sister, and the United Task Force. You can find more info about these resources at shalomtaskforce.org. It's my pleasure to introduce tonight's speakers. Erin Bistricer joined Sarah's Voice in 2012 and is the senior staff attorney. Throughout her career at Sarah's Voice, Erin has litigated numerous complex family law matters in both family and Supreme Court. Erin works exclusively with low-income domestic abuse survivors and provides services with respect and empathy to the particular challenges that they face. Currently, Erin has been supporting and holistically advising current and former clients on a host of issues unique to the outbreak, such as custody visitation, unemployment, benefits, mortgage housing, and student loan payments. Rachel Marks serves as the Vice President of Shalom Task Force and is affiliated with the law firm of Schonfeld and Goldring. He's a seasoned litigator and former criminal prosecutor. Rachel is a graduate of Barnard College and received her JD from Fordham Law School in 2003. Rachel is active in community affairs and has a proven track record as an advocate for those in need. Due to the sensitive material being discussed tonight, we have disabled the chat function on this webinar. You can submit questions through the Q&A feature. Please note, if you want your question to be anonymous, make sure to mark the anonymous option before you submit. If you are on the conference line or watching through Facebook Live, you can submit questions by emailing education@shalomtaskforce.org, or you can anonymously submit them by visiting shalomtaskforce.org/LCW. This program is being recorded and will be available on the Shalom Task Force website under our COVID-19 resource page, which is on the screen now. Thank you for joining us this evening, and we extend our hopes and prayers for safer times.
Thank you so much, Avital. Good evening. I'm Rachel Marks. Thank you for joining this evening. Before we begin, I must personally, on behalf of the community, express my deepest appreciation to those at Shalom Task Force who have worked tirelessly during these very difficult times to provide services and support to all in need. It's important to note and recognize that each of the Shalom Task Force departments are open and are available to support you. These are unprecedented times. There's a tremendous amount of stress and a great amount of uncertainty. Our goal this evening is to provide some guidance and insight in uncharted territories. We don't have all the answers, but we're here for you to support you, and together we can try and figure it out. Erin, thank you so much for joining me tonight. Erin and the Sarah's Voice legal team have been helping callers and clients navigate through the pandemic. Nearly every day now, new information is coming out from the courts and administrative judges that is meant to guide us. Many people going through a divorce or who are already divorced are faced with many questions and challenges, and we hope to address those this evening. Let's jump right into it, Erin.
Thank you, Rachel. And thank you for all those who are tuning in today or listening to this later as a recording. We're really here as a resource, and we appreciate the interest that you have. And, you know, like Rachel said, we don't have all the answers, but we're hoping that we can give some clarity and that this is helpful to you.
Absolutely. So Erin, like I said, we've been hearing a lot from the courts from the past few weeks. There are new memos coming out all the time. What is going on? Can you summarize for us what's going on with the courts?
So it's been, you know, in flux, but it's starting to stabilize. And essentially the takeaway is, you know, there's very limited applications that the courts are entertaining right now. But before I get into that, I just want to very briefly go over for our listeners the differences between family court and Supreme Court. Both of them can hear family law related cases. I would say like the major difference between them is that Supreme Court will hear a divorce. And that is started when you file an application for a divorce, and it will resolve all the issues like custody and visitation, child support, spousal support, and it could also hear orders of protection and do property and debt distribution. Whereas with family court, they only hear cases that deal with support, custody and visitation, and orders of protection. So the guidance, it's similar in both cases, but just the procedure is a little different. So essentially what's going on right now is that if you're already in family court, you're going to stay in family court. And if you're in Supreme Court, you're going to be in Supreme Court. And like I said, they're really only limited cases. The family court, you know, essentially they're taking, for the exception of juvenile cases, they're taking emergency family offense petitions and writ applications when there's a court order for custody or parenting time, which means that if someone's not producing the child, you can file this application called a writ, and it essentially asks the court to produce the child, and then the court's going to take it from there. They're not very common, at least they're not supposed to be. And even though they're saying emergency applications, and there's a little bit of non-clarity of what that means, like could that mean an emergency modification petition? My interpretation and the interpretation of other practitioners I've been speaking with is that it's really limited to these real emergency situations where there's a court order and the child is not being produced. In Supreme Court, you can also do emergency family offense petitions. Those means order of protections. And they say emergency applications, but really the stress is that, at least with emergency applications, our sense is that someone might be screening them. And you really should be filing under very extreme circumstances. And everything right now is also pretty much remote. So the filing procedure is a little different. We posted on our website as part of the resources, the way that if you're representing yourself and you don't have a lawyer, how you can file an order of protection or an emergency application. There's an email address and you essentially email it and then you'll get followed up from there.
Right. And to summarize just a bit, while the procedure seems to be pretty similar across jurisdictions, and a note on jurisdictions for our participants, we are talking about New York State. Okay, when we're talking about what's going on in the courts, procedures and laws, we're talking about New York State. Okay, within New York State, there are different, there's New York City, there are different counties, and across the board, everyone is pretty much following similar rules, but in your particular jurisdiction, the specific procedure of getting before a judge or getting into court might be slightly different. Okay, and you want to consult with your attorney, or you can call into Sarah's Voice to ask specific questions about that if you're unclear about your specific jurisdiction within New York State. Okay.
And I also just want to clarify, you know, because initially the courts were handling some sort of very limited financial matters, such as a violation of child support, which could have a really strong impact on a family. They were entertaining those kinds of violations, and then now they're not. So What we're really talking about is no support applications, no violations even on custody and visitation. It's really orders of protection and these writ cases. So it's really limited, and it is changing. So another thing that we're putting on our website on the resources is the court's page, and you can go on that and check out the memorandums that are being issued on this topic. A lot of them right now have to do with virtual, like, you know, the standards for how the courts are going to conduct themselves. Everything is done remotely, so you're not even going to go in front of a judge if you do have a hearing. But if you look into what was being posted like around March 22nd, March 23rd, you'll see these directives on the court website.
Right. And while the courts may not be hearing financial matters, the child support collections unit is still functioning. Many people pay their child support through the child support collections unit, and then it is paid to the custodial parent who's collecting the child support. They are still open. You can reach them by phone. You cannot go into their offices, but you can reach them both by phone and by email. I myself called them yesterday with a few questions to see how they were functioning. And I had to wait a little while, but they were open and I got through. And the word there is, you must pay your child support. I asked, what about, there are a lot of people who are now out of work, they're cut, their pay is cut, or they've been laid off, or they're suffering financially. And the answer to me was file for unemployment. So people are not being excused from making their child support payments. They must still make the payments, and if necessary and applicable, file for unemployment. In terms of enforcement, only time will tell. We really don't know how long this is going to last at this point. If we're talking about, a few weeks, then we may not get to that point. If, God forbid this goes on longer than that, then the courts are going to, and courts and child support collections unit, the whole community is going to have to modify and reconsider the way that we do things to address the longer picture. Okay, so Erin, you talked about, you mentioned orders of protection. The courts are open for orders of protection. What is the standard for filing an order of protection? Has it changed at all?
The standard for filing an order of protection, what essentially you need to show is that the person that you're filing against is a danger to you or to members of the household. There are different kinds of orders of protection, and depending on the relief that you're asking for example, let's say you want the abuser excluded from your home, it might require more severe or concrete evidence of abuse. Currently, the standard has not changed. So it's not that you have to show these extraordinary circumstances to get an exclusion order. If that's a concern, the standard is still the same. You can still file. They're going to apply the law in the same way. The only difference is the filing procedure, and you're essentially doing everything remotely now. But the first court appearance, like normal, is going to be done just you. It's called ex parte, just you and the judge. The other side hasn't been given notice yet. The only difference, again, is that it's now being done through a phone call rather than you going in person to see a judge.
Right. So that's great. And it's good to hear that the standard hasn't been heightened. Last week, the director of Shalom Task Force, Dr. Shana Friedman, did a live on Instagram where, she really discussed how scary of a time this is for victims and survivors of domestic abuse, many of them living in the same home during this quarantine period. So it's good to know that orders of protection are available, that this avenue is available to them, and people should definitely know that's something they can reach out for. Very important.
And just to say, another resource that is really helpful when it comes to orders of protection are the family justice centers. There's one in each borough in New York City. So if you're in New York City, you can definitely utilize them. Now, they were, physically locations that you can just walk into without an appointment. So those locations are closed, but they are still operational through the phone. So again, on our website, we put in a link to all the numbers for the family justice centers. And they're not just good to get an order of protection drafted if that's the type of assistance that you need, or if you need help filing it. They also have a lot of other resources out there for people, and they're just really good to use. So if you're considering filing, you can call my office, you can speak to a lawyer, but you should also definitely consider calling the family justice centers.
Absolutely. Absolutely. During this time, everybody has hunkered down. Everybody is staying home or staying in place. Now we get to the questions of custody and parenting time. What place? Who's home? With which parents? And how is the court responding to parenting arrangements during this time? Or what is the court's response?
It's been mostly silent on the substance issue. So, you're getting a lot of guidance from the courts on what's going on with regards to, are the courts open? How do you file things? So they've really been on, trying to give us information about that. But in terms of how a case would be decided, what to do with a court order that you already have, it was issued during a very dramatically different time. there hasn't really been any guidance. I mean, some other jurisdictions outside of New York has posted, we either expect visitation to resume as normal, or actually we're suspending visitation during these times. But New York has not done that. Judge Sunshine, who is the chief judge for the matrimonial divisions, he posted an article on Friday in the New York Law Journal, which you can read. And again, it's also posted on our website. And, you know, his memo really encouraged a general principle. It wasn't too, again, he's not commenting on the specifics for every single case, but what he's doing is that he's trying to send a message that the courts are encouraging parents to come up with creative solutions and to work together and to have a united front. And, you know, it's really about putting the children first, and to like realize that, you know, we're in a different landscape right now, and the reality is that not everything's going to be ideal, but try to shield your children as much as possible, which again is a very helpful reminder to say to parents, look, it's not about you, it's about the general, you know, pandemic that's going on. You need to work together. But again, it's very fuzzy on specifics. So we don't have guidance right now from the courts on how they're going to interpret a case if someone's not following the court order.
Right. And that's where, you know, things are really very case specific, and where we need to brainstorm a little bit together with our clients. Me and my private practice, and I know Sarah's voice as well, we've been getting a lot of calls with specific situations. And that's, you know, we have to come up with practical solutions, and also kind of keep in the back of our minds, well, what would the court do if this were a normal period? And what do we anticipate they will do when this is all over in the future? Because the court is going to look back on this period and see how the parties, how each parent dealt with issues during this time. Were they able to work together? Were they accommodating? Were they thoughtful and kind? Really almost like basic kindergarten. Were they able to play nicely together when we're in an emergency situation? And the court is going to take note of that. And that's exactly what Judge Sunshine had said.
Yeah, and he's really encouraging the same advice that lawyers give, or what the judges encourage the parents to do under normal circumstances. So, and I think a lot of people would say, like, well, easier said than done. If we could get along, we wouldn't be in this contentious case. What if I have an abusive ex-partner? So I know it sounds you know, like an oversimplification, or it could sound like an oversimplification, but I think what he's trying to say is, you know, I know that things are really tough right now, but don't lose your heads. Right. And what we're going to talk about later in this session are some practical ways to kind of go with the message of what Judge Sunshine is saying, and apply it to your individual circumstances.
Absolutely. Earlier this week, I spoke with a judge in Brooklyn who said that she and her law secretary is an attorney that works for the judge, have been conferencing some kind of you know, some of the emergency type of situations that have popped up. And their advice to the litigants and to the parties is, you know, you have to work together during this time. You have to be prudent. You have to do what's in the best interest of the child. And you have to put your differences aside to make sure that everyone is safe and healthy during this time, even if it means that you're not getting your way. Again, easier said than done, and we'll go into some more of the practical tips on how to try and achieve that in a little bit. Okay, so we've discussed now the Supreme Court and the Family Court, and those are all civil courts. What about the Batei Din, the religious courts? Where are they? What are they doing right now? A lot of people during the divorce process will have involvement with a Beit Din, with a religious court, for the purpose of getting a get, a religious divorce, but also sometimes for arbitrating some of the issues. I know after reaching out to the Beit Din of America, I was told that if both parties would consent to a din Torah and arbitration being done remotely through a video conference or other means, they are willing to go forward to do that. I stress an arbitration, not a get. I spoke to a number of other Batei Din who said right now they are kind of on hold. They're waiting to see what happens until after Pesach, until after Passover, to see how things progress with the pandemic. And then at that point, they would make decisions. In terms of the get, the Jewish divorce, again, the Beit Din of America said that they right now have not done any gittin yet. However, they would be willing to consider an emergency get. And what that means is that if there would be a lost opportunity, if it were not done right now, there might be a lost opportunity. Perhaps a get would be withheld, and we don't ever want to lose that opportunity. So in that kind of situation, again, that's a case-by-case basis. It's something that they would evaluate, but something they're definitely willing to consider, which is really nice to hear. Other Batei Din, again, said that they, they're hoping that this resolves sooner rather than later, and after the holiday, they would consider what the next steps are. There's really, I wish we knew, everybody, the whole world wishes that we knew when this was going to end, and hopefully that would end, more positively than it looks right now. But we really don't know. And again, there's so much uncertainty. So we work with facts on the ground at this moment, and that's where we are right now. So, reach out to your religious courts that you're dealing with on these issues and see where they stand, if it's something that's applicable to you right now.
And I'm just going to add very quickly, I'm sorry, Rachel.
Sure.
Just in case it's not clear, arbitration, you're going to need two-party consent to do it. And
Yes.
Arbitration is not always, especially in domestic abuse cases, a forum that we would advise people to do, because there are differences between arbitration and the civil court. So, right now arbitration might be one of the few ways to actually start getting parts of your case heard, because if they can set up a remote session and they're willing to do it, like Rachel said, not all rabbinical courts are, but if there is
Right.
one, it might seem like an tempting option, because at least you can get something moving, but there are ramifications to that. So if you're going to arbitrate or think about arbitrating, just please first speak with a lawyer and see if this is something that you want to pursue. And, again, with the religious divorces, there are rabbinical authorities saying, like, you need to have at least some type of in-person contact, at least partially, to get those done. And that's why those are mostly on hold right now, except for maybe these emergency cases. But there are still ways, if you're at least at that stage, if you're thinking like, we're nearing the end of my case, we're drafting a settlement, the only thing really is, how do I get my religious divorce? There are ways that your lawyer can put protections in there to make sure that you do get it once the state shelter-in-place policies are lifted.
Absolutely, really important. Another point that I would just like to make is that Erin made a very good point about using this time to perhaps arbitrate, but I also must say that using this time to mediate is particularly important and a useful way to move forward during this time. Mediation can be done through a Zoom, the same way we're doing this. It doesn't have to be in person, and it's a productive way to move forward if you are able to. Again, in a domestic violence situation, it might not be appropriate. It has to be a way, a safe and productive way for the parties to settle their divorce. But if it is appropriate for you, this is a good time to do it. And in terms of you're nearing the end, Erin, you mentioned nearing the end of your settlement negotiations, and you're almost ready to put this behind you and come to an agreement. What are some of the ways that attorneys can make sure that happens? Well, all the time in agreement that a get happens, all the time in agreements, we'll put, if a get has not been given, and very often a get is given simultaneously or shortly after the parties sign a divorce agreement, a separation agreement. And there'll be a clause in the agreement that could be as specific as you want it to be. And in these situations, I really do advise that it be pretty specific, saying that within a certain amount of time, following restrictions being lifted, you can even put in, number of days or whatever it is, the parties will appear before, and you can put in a specific date in order to effectuate the get. And that way, there's something in there that's giving you a little bit protection. So you shouldn't worry about signing the agreement and having the get kind of out there without it being given. So that's really important.
Yeah, and I just want to reiterate, correct me if I'm wrong, Rachel, the Beit Din that said that they're doing it on a case-by-case emergency situation, that's the Beit Din of America?
Yes, they said they have not done it yet, but it's certainly something that they would consider on a case-by-case basis if it's an emergency and there'd be a lost opportunity. I don't think there's anybody that wants I lost opportunity in giving a get. You know, when a get has to happen, I'm sure, Erin, this, you know, in your practice, I imagine that you've had this as well. It has to happen. You make it happen. You make it happen. You call the parties together. You call the SOFR. It doesn't matter what's going on. You drop it. You get the part. You know, you drop what you're doing. You get the parties together, and you make sure a get is given and accepted.
Yeah, and I can personally speak, I've worked with that basin before, that they're very sensitive to this issue. And they know that if there's kind of like a one-shot time to get it, they're going to do what they can to make it happen.
Right.
And they'll do it in a safe way as well. Like, it's not.
And that's not to say that other Batei Din aren't. I've been, you know, we've done emergency type gets at other Batei Din also. I think, you know, I'm hoping that everyone just kind of has to, you know, find their feet and figure out what's going on here. And, you know, when it's right before a holiday, things kind of slow down in the rabbinical courts anyway. And, you know, we're within a week of Passover. So hopefully we'll have some more clarity in, you know, in 2.5 weeks from now, 3 weeks from now, when it's over and behind us. And then we'll see where we're going with that. Okay. Let's move on if that's okay, Erin. Okay. How is the legal community responding? What are lawyers saying? What kinds of advice are they giving their clients? I know that we're doing a lot of out-of-the-box thinking and coming up with creative solutions. Tell me what you're doing at Sarah's Voice.
You know, it's been really busy. I have to say, when the courts closed, I was like, okay, there's going to be a limited amount of what I can do in my cases. It's probably going to be a little slow. And it has been the opposite, because there's been a lot of discussion and a lot of brainstorming and advocacy that's been going around the legal community, and various organizations who are keeping in touch with each other through Zoom chats, through listservs, and we're all talking about this. And, you know, I just want to say, before I get into the custody, which is like really the meat of this session, we are not ignoring the financials. That could be a whole other session. But, you know, again, basically, without access to the courts, there's not much that can be done. I want to clarify that the child support collection unit, if you have an outstanding maintenance or spousal support order tied to a child support order, they can collect it too. So they don't collect just for spousal or maintenance. They will collect if you have a child support and a spousal support order. And I think unemployment is really key right now, because if your ex-partner loses the job and is not able to pay child or spousal support, they can still collect unemployment, and the unemployment can be garnished by the support collection unit, or should be sent to the support collection unit. So that's why we emphasize that if you qualify, or if your ex-partner qualifies, this is something that really should be utilized. If you need to make the payments, or your ex-partner needs to make the payments, it can still go through the SCU as business as usual. So getting to the custody component is that, you know, all the legal providers are recognizing that the parents are stuck right now, because they have these court orders and they're in a completely different landscape, and it's unclear how the courts would react. So I think, you know, when we are advising, we kind of know that the courts are looking for parents to quote unquote step up right now, and understanding like that's really easier said than done. And there's a lot of sympathy about that. You know, from what I've been hearing is that we've been exchanging ideas, and even though I don't think any of us can say, yes, we know that the court would react like this. I think we've essentially, from my conversations with legal service providers, have been coming up with a consensus on how we're going to be advising our clients through this. And like, we're all pretty much giving, like from the sounds of it, we're all giving very similar advice. And I think that's something, you know, even though we can't promise the courts would see it that way, I think if the legal community is saying, you know, this is what we think is, you know, the right way to do it, I think that gives some level of security to a litigant to say, like, you know, a lot of lawyers are on the same page about this.
I think a lot of common sense and just good faith effort is being applied here.
Yeah, I think that's right. And like, you know, we're going to flesh that out a little bit more, but that is like the two takeaways. You know, use your common sense, but stay safe. And, you know, again, what the courts are looking for is, what they don't want is either the custodial parent or the non-custodial parent using this as an opportunity to gain an edge in some way. Absolutely. And as long as I think you can avoid doing that, our hope is that you should be okay, at least with regards to like what your rights are.
Right. Okay. So now let's talk about practical advice. What advice can we give to divorced parties, separated parents? What can we offer them to try and make this time a little easier?
So Rachel, do you want to start with the supervised visitation arrangements?
Sure.
Let's do those, because they're a little unique from everything else.
Yeah, absolutely. Okay. So there are a lot of, there are people who have supervised visitation. So when they visit with their child, it is supervised often in a center or in a professional's office, and those are all closed. The physical locations are closed. So, people are left with not having their parenting time, not being able to see their children, which is devastating to both the parent and the child. So how do we deal with that? The number one thing I can tell you is don't just give up. Consult with your agency or provider for alternate plans. Perhaps there can be video conferencing where the provider is present as well. Some kind of Zoom conference or something like that, where you can have multiple people on, so you can have parent, child, and provider supervising in a similar way that they might at a center. That's an idea. Perhaps a phone kinds of conference. So there are different ways that parents can brainstorm with their provider to try and find another way to still have meaningful contact with your child. Okay, nobody wants to take that away. It's important, again, to both parent and child to have that kind of meaningful contact. And it's just important to remember that meaningful contact doesn't have to be physically present, doesn't have to be in the same place. It can be conversation, it can be a video conference, you can play a great game through video conference. And that's a good way, even for non-supervised visitations. And we're gonna touch upon some of the issues that have been coming up. If parents are not able to see their children, perhaps they've been diagnosed with COVID, or they're in quarantine, or there are high risk population issues coming up. There are a lot of different ways that we can still have meaningful contact with the children. Just in fact, today, when I was out walking my dog, I noticed that a parent in the neighborhood who happens to be a client was outside playing. Yeah, the parent was outside playing with their children, not at their residence, but at their ex-partner's residence. So they're outside, still having meaningful contact, being able to see each other, and really thinking out of the box. So this is obviously not applicable in a supervised visitation scenario, but in a different scenario, it's a great idea to make it work in this type of situation.
Yeah, and just the thing is with the supervised visits is that I just want to reassure the custodial parents, if you have a situation where the provider or the supervisor, so a lot of times it's through an agency, but sometimes it's through a community member, it's through a relative. If that supervisor doesn't want to supervise right now, I mean, the courts aren't going to blame you for that. Right. You should check with that person if they're willing to do it, or if you're comfortable. Let's say you might be under a quarantine right now, or you might have circumstances that prevents you from going out of the home to get to this very specific location. So I think, I think what Rachel is saying is right. Like, this is an opportunity just to completely cut off the contact, but to the extent possible, try to replace that in-person contact if it's no longer feasible with the electronic visitation. If you do have an order of protection and you don't have a carve out allowing you to do FaceTime or visitation arrangements, and some orders of protection do have that carve out, but some don't. If you're represented, try to get your lawyer to coordinate with the other side to try to arrange those FaceTime visits, or try to get maybe someone mutual who can reach out to the other parent to say, yes, these visits have been canceled, but you can still have them through the computer if you call this number at this time or something like that. But again, if you have the order of protection, make sure you're checking in with your lawyer, do what's safe.
Absolutely.
And, but if you don't have an order of protection, understand like there are methods, and like the court is not going to blame you if, like, let's say your agency or supervisor is not willing to do these visits right now.
Mm-hmm. And always, document, keep a log, so that way if something, comes up later on, you're able to say, well, the provider wasn't available, we tried and this didn't work, or whatever it is, just document, keep a record of it in case you need to refer to it later on. Absolutely.
Yeah.
Okay. Okay. So let's talk a little about, Erin, what's the best way for when we're not in order of protection situations, not supervised visitation situations, what's the best way to facilitate meaningful contact, okay, even in person during this time?
Okay. And I'm going to emphasize that this is not a one size fits all. This is, a general guideline and frame that we find is pretty comprehensive in addressing what's going on, but there's going to be situations where this is not going to cover. So this is why I really think it's important, if you have questions, to really reach out to us after the session or to a lawyer of your choosing to get more specific targeted advice. But number one, I would say this is a medical pandemic. So speak with a doctor. Talk to your child's pediatrician, talk to your doctor. I mean, this isn't just about your child's risk, it's about your health as well, and about the general health of our community. So you might be living in a household with members who can be particularly vulnerable to this disease, or you can be yourself vulnerable to this disease. So, I would start with the pediatrician, but don't forget your doctor as well, because they're an important piece and you're an important piece too. If possible, get a doctor's note in writing, or if you're texting your doctor, emailing something in writing with the doctor's recommendation. So I think that's the number one thing, because we're talking about a medical issue, and no lawyer or judge can really say with certainty what's the level of risk in a particular case.
Absolutely.
And then the next thing is to document, as Rachel said, you're going to get tired of us saying this, is to document everything.
Everything.
Because it's like
doctor,
a lot of
everything.
Yeah, we're not reinventing the wheel here. A lot of this advice is what we would say in a normal case. When you're talking to the other side, you try to prioritize text and email or WhatsApp over phone conversations, and send a very clear message to the other side of, this is what the doctor has been advising as much. And it's not a bad idea to also reinforce what the CDC or your state's policies or your county's policies are with terms of shelter in place guidelines. These are the policies we're supposed to be following. This is what the doctors have said. Based on that advice and based on that guidance, this is what I would say is what I would want the parenting arrangement to be. And if you don't agree, please respond to specifically why it is that you think we shouldn't be following these directives. State state what your concerns are, state what your reasons are for your position. Do not attack the other side. Do not assume that they're being selfish. Just say, make it more about, this is what I want, this is what I need, this is what I suggest, and this is why I suggest it. And you might have to go through several emails with this, but always, press the other person for very specific measures that they're doing to stay safe during this time. And again, see if they're in line with what the medical professionals have been addressing. So be comfortable, but not confrontational with asking the other side to specifically address what you brought up. And
it's also important for the parties to take a look in their agreements and see who's responsible for the legal custody decision making. This is in a case that's already post-divorce. Is there one parent that's responsible for medical decision making? Is there joint custody there? And that'll also influence how decisions are made and how these conversations are had. Of course, these conversations, ideally should always be made and had with respect and in consideration of the other's point of view. But it really matters which parent has custody and who gets to make the final decision.
Yeah, and what Rachel's referring to is what we refer to as legal custody, the decision making, especially specifically in this case in the medical realm. Sometimes the parents have to make joint decisions together on that. That's called joint custody in the medical field. And sometimes one parent will have sole custody. Usually it's the custodial parent. But there's usually
there could be
spheres. So we're talking specifically about the medical.
Right.
And
exactly.
Usually even if you have sole custody, there's a consultation period. So you need to go through that. Again, orders of protection cases are different, but you should be having a conversation, a dialogue. You should be honoring the spirit of your agreement, which is to treat each other with compassion, prioritize the children's needs, and prioritize access to the point where it's practical and not unsafe. Because I think really what we want is, we're not going to tell a client, put your health at risk, but be aware that you should do what's best for your family, but the courts might give you pushback. And that might take the form of an extreme case where the other side goes and files a writ, or it can come after this pandemic lifts and you can go back to the courts and maybe they'll either file a violation against you, or maybe they'll not do that, but they'll just bring up what happened in court. So as the legal community, I think we're thinking, look, I don't know if a judge is going to say to someone, I'm going to hold you in contempt. I'm going to hold you in violation of the agreement or the order because you didn't do what was said to be done. But in the back of their head, they're looking to see if how you acted was reasonable. And that's still the standard. Like I said, it's an extreme situation, but the advice is still pretty much the same. Consult with appropriate professionals, document, act reasonably, and get across your position that's backed up by facts.
Right. Okay. Can you speak a little bit towards Pesach? Passover's coming over next week. That's difficult for a lot of parents who are anticipating that they may not be able to spend the holiday in the way that they had hoped to with their children. They may still want to spend the holiday with their children if they're not their non-custodial parent, or perhaps it's their year for Passover or whatnot. How do you suggest that people tackle the upcoming holiday?
It's really tough. So, obviously, again, the best situation would be is to come to an agreement with the other side. But I would say, like, again, even for Passover, use the guidelines from your doctor and use the guidelines from what's going on from like what the city and the state are issuing. Try to come up with a visitation arrangement that's in line with that. It might not be possible for this year for there to be a parenting arrangement for Passover. So maybe if you're saying like, look, Passover is not going to work out, but maybe you should take the time for Sukkot instead. Try to offer something analogous because I think that would go a long way of showing like this is about good. This is not about taking the time away. This is about putting the time on hold until this situation lifts.
Well stated. I agree. We're going to have to, people are going to have to be creative and find ways to make up the time later on and have their ex-partner and parent feel that they're still able to see their child and we're not trying to take something away from them. Very important. Okay. Now, does your advice change for domestic abuse scenarios? And I don't just mean the Passover, I mean overall. Putting on our domestic abuse hat. Tell me about that.
Domestic abuse cases always have to be handled with a bit of a different approach. I mean, some of these creative solutions that we're talking about, like having the non-custodial parent come outside of your house to have some visitation, working through these like email exchanges or text exchanges. First of all, if there's an order of protection, the communication is going to be severely limited. So in cases like that, yes, the advice would change. Like I would not encourage anyone to lose the protections of their order of protection trying to work out a parenting arrangement. Mm-hmm. Safety really does come first. And I think also, while the courts have been encouraging and while a lawyer would tell you, we encourage you to try to work something out with your ex-partner, we recognize that with abusers, like you sometimes just can't reason with them. And that's often the case. They just don't, it's really about them, their egos, their narcissism, and their control. And they use children as a form of control. And they're the ones who would really try to weaponize a situation like this for their own ends. So even if you're trying to keep the communications as respectful and direct as possible, you just might not be able to convince the other person. And that's not your fault. That's just the way it is. But I want to be clear that if you have the capacity to communicate, still try to do that, but say very clearly what your boundaries are, what your expectations are. And it is not appropriate for anyone to use this as an opportunity to verbally abuse you. So if the communications get verbally abusive, it doesn't mean you have to keep trying. You can shut it down at a certain point. But again, documentation is still key in these situations. And I would say, like, again, with domestic abuse survivors, there's resources out there. There's organizations like mine that we particularly work with this population. There's the FJCs. Also, like, this is like really the time to also like really for everyone, not just domestic abuse survivors, is to rely on mental health services. If you have a therapist, like this is a particular situation where they can try to help you brainstorm solutions.
Absolutely. Very important. Very important to check in again with medical doctors, with mental health professionals to guide your decisions and to figure out what's best for all the parties here, for you, for your child, to guide you through this very difficult time. Okay, Erin, I think at this time we've gotten, the hour is late and we've gotten quite a bit of questions, both before we began tonight and I see them coming in here throughout the program. We will do our best to address these questions, and I think the best way to do it is to speak to a few categories of issues. Realistically, we were not going to be able to address every single scenario, and of course, you can continue to reach out to Sarah's Voice with any more questions or concerns that may arise. At the end of the program, we will put up all of our phone numbers, websites, all the information that you'll need to reach out to the various referrals and resources to help you with that. Okay, so Erin, let's turn to some of the questions. Okay, I'm going to give you some scenarios and we'll work them out together. Okay, I am the custodial parent. My ex-partner wants court-ordered visitation. My ex-partner is threatening to show up at my house without my consent to take the children. What should I do? Wow. Okay. This is actually it's a scenario that we've heard quite a few times this week. I'm sure you have as well, Erin, or over the past few weeks. And I think that there are some relevant factors and details that we still need to know in order to answer this question or begin to dissect it. So I think that we should insert our own variables here and talk it through that way. Okay, let's say the ex-partner has a positive COVID diagnosis. Okay, so let's say ex-partner has court-ordered visitation, wants to come see the kids, and has had a COVID diagnosis already. What do you think?
I would say, I think it would be perfectly, again, not judge, but I would say it is reasonable to deny that visitation until you have a doctor's note saying that this person is safe to be around. So if he doesn't have the doctor's note or is not willing to get a doctor's note, I think there's something off about that situation.
I agree.
I would advise a client to, again, generally, I would say if you don't feel safe with it, don't open the door.
I totally agree with you here. We know definitively that there is a diagnosis, and it doesn't mean that the ex-partner will not get to see the children at some point. We just need medical guidance to determine when that point is. What is appropriate for the safety, for everyone's safety, for the children, for other people in the home? When is the right time? And that needs to be guided by a medical professional. Okay, let's change it up a little bit. Okay, ex-partner, let's say ex-partner does not have the diagnosis, but was quarantined.
It's trickier.
It's trickier.
So the thing is with the quarantine is like, the guidelines are saying when the quarantine is over, like you stayed inside for 14 days, this person, my understanding of the guidelines is that these persons are safe to be around. So it is a trickier situation because we know that this person has been self-isolating for 14 days. I would then move the inquiry to, well, what is the person doing now that they're out? Are they going to be following the social distancing rules? Because if they're not, and we're going to talk about that soon, I think there's still a problem here. And I also don't think, like, again, you might not get something clear in writing from a doctor about a quarantine situation where someone was exposed but showing no symptoms, but still not a bad idea to check in with your doctor, especially if you have, again, vulnerable people in your household or you're vulnerable yourself, or if your child is vulnerable, to talk about this person just came out of quarantine and is it like, yeah, they weren't showing symptoms, but people don't always show symptoms. So maybe get some clarification on that.
Mm-hmm. And you mentioned something very important there. We know where they were for the past 14 days, presumably. They're in quarantine. They haven't left their home. They haven't had any further exposure. But what's going on now? Now that they're out, are they going to be practicing social distancing? Are they going to be following the rules? Are they going to be, pausing as New Yorkers are supposed to be doing now? Are they still using public transportation and going to work and going to the supermarket unprotected and, everything else that's out there? We kind of have to have a picture. Okay, both as lawyers who are advising our clients and the parties, the parents need to have a picture of what the other is doing and making these determinations. So let's take that scenario, okay? Let's say the ex-partner was never quarantined, but the custodial parent knows that the non-custodial parent is not socially distancing.
Yeah, and this is also another tricky situation, but I think it's less tricky when you know that they're not following the guidelines.
Right.
So again, number one, go to the doctor. Again, we don't know exactly how any doctor would react if they were willing to put in writing, but I think doctors might say, like, if someone's not following social distancing, they're increasing the likelihood of infection and spreading it. And if you can document in your communications, I know you're taking public transportation, I know you're going to friends, or I know you're going to family, I know you're going to whatever it is that you know that they're doing. And we're not talking about someone who is going outside for a walk or someone who's going out for groceries. We're talking about someone who's not following the shelter-in-place guidelines. If you know that they're doing that, I think, again, we don't know how a judge would react, but I think if you get your ducks in a row with the doctor's recommendation and your documentation of why you're not comfortable, I would say, again, you want to put your family first. You just want to make sure that you come across as reasonable. Offer alternative ways of contact, such as, again, we're talking about electronic, we're talking about some level of makeup. What that makeup is going to look like, I think depends on how long this lasts, but say, like, we're going to give you reasonable makeup time. Again, really just trying to, like, draw out through respectful communication. Again, to reiterate, this is not about taking time away. This is about making sure everyone is safe. And talk about, like, I'm scared. This is my situation. I have a child. I have elderly parents in the home, or I myself have a condition. I can't take a risk. And try to emphasize that. But I would ultimately say, like, look, I think there is grounds here for denying visitation on that, but again, what a court would do, we can't say at this point.
Right. Now, we have another question here that just come through that's along the same lines here. Ex-partner is showing symptoms, but is not a confirmed case. I think we're going, you have to then follow, our first scenario of a COVID diagnosis. If they're showing symptoms, I'm not a doctor, you're not a doctor, but, I would hope that parents would then, err on the side of caution and protect their child and do what's best here. What do you think?
I think, yeah, I mean, like the problem is that there is a lack of testing right now, and that's not a secret. So if you're going to say, well, just because you weren't tested doesn't mean you don't have it. I think people would find that, that's a reasonable thing to say. So again, like consult with the pediatrician.
It shows bad judgment. It shows bad judgment.
Yeah. And I think we want to emphasize
later on.
I think we want to emphasize that the non-custodial parents' actions are also being scrutinized, and what's going on here. Like the courts are not just looking at the custodial parents, they're looking at the non-custodial parents. Were you being reasonable? Right. So I think, like, again, with all these scenarios, when we're talking about social distancing, you want to be in line as possible with the CDC guidelines. And that means, if your partner's taking public transportation, that's a different case than a partner or an ex-partner who has a car. If someone has like their own private car and they can just shuttle back and forth and their home is safe and your home is safe, that's going to be a different landscape than someone who's living with a family member with both sides family who can be either vulnerable or who can be exposed. But going to the question of like, what happens if the non-custodial parent is the one with the vulnerable relatives? I think you need to let that be that other person's call. I think it's like, I think we're all thinking about it, but that's going to be the other side's call. Because we've been getting questions about like, what if they're the ones with the vulnerable population? And I was like, that's their risk.
Yeah, I've gotten that too. You mentioned transportation and passing, and I want to bring that up. There are a few questions about that. Children taking transportation to visit another parent, or parents living in different counties or even in different states. Is this a time when children should be traveling? Is it safe to be traveling? What happens if there are orders put in place in either state or even county where you can no longer move? You can no longer travel between states, and then a child is stuck in that area. Is it wise then to be having that kind of transfer between parties, between parents?
I don't think it's unreasonable for someone to say there could be a lockdown put in place. And if I'm sending my child for visitation, am I going to get my child back if they cannot cross because they're not allowed back in after a lockdown? So I would say, like, again, monitor the news, see how likely that is, but try to come up with, again, another situation where you offer substantial time. I think the general consensus is this is really not the time to be traveling too much. But again, if we're talking about private cars
again, are different public transportation.
Yeah.
Okay. All right. Let's move on. Next scenario. I'm the custodial parent and totally overwhelmed. My kids are young and demand my attention all day. I cannot get work done, and I'm scared of being fired. I do not have the ability to leave the home and do errands because no one watches the children. My ex-partner is refusing to exercise their court-ordered visitation. What do I do? This is so interesting because it's really the opposite perspective of most inquiries and most things we're seeing. It's really interesting to see. I'm so happy that this person reached out. Showing their vulnerability is really important, showing that, it's a really hard time for parents who are home, who are homeschooling and working, a single parent trying to juggle it all, care for their children, work. This parent still has to work. They're saying, I can't get my work done. What do we do here? Can we really force the ex-partner, the other parent, to come and take their parenting time?
Yeah, no, it's a really hard situation on a custodial parent. And, in any situation, I always say you can't force a non-custodial parent to exercise their parenting time.
And then under the best of circumstances.
Under the best of circumstances. And I say, let that speak for itself. But in this current situation, I don't think the courts would be unsympathetic to a non-custodial parent who might not want to show. But I still think they need to reasonably document why they're not coming. Yes. And then I would say from your end, still use the same advice, the doctor, the documentation, maybe the doctor is saying there is no risk. And if this person has a car and their own household and the doctor is saying it's safe, and the person's still not coming, you can document that. And later on, maybe it could be evidence in court that maybe this person shouldn't have the same amount of legal custodial rights as you, or maybe this visitation schedule that they're asking for that they're not even using isn't really something that needs to be put into a court order. But I would say, again, try to think of those creative solutions that might ease your burden. I think there's nothing wrong with saying, like, look, I could really use the help right now. So if you can at least carve out some way of having visitation, maybe like the scenario that Rachel said, meet outside the house, stay some distance away from each other, at least like take an hour off my hands here, or FaceTime them in a way that might be more engaging, like plan an activity for them so they actually stay engaged with you during this time.
Right.
Maybe if you feel safe enough or comfortable enough saying, like, I can't leave the house, but I have all these errands to do. Can you do that for me? And then drop it off outside of my house.
That's an excellent suggestion.
Yeah,
Really
just make make your needs heard. Again, you can't force someone to do it. I wouldn't attack the person. I don't think the court would like that, but just very like straightforward say, like, look, this is what I need. If you can't do this, can you at least do this?
Right. Yes, absolutely. That was just an interesting perspective. Okay, we're running out of time here, but okay, let's go on to the next one. I have a 50-50 schedule with my ex-partner. We're not on the same page about socially distancing guidelines. I am following them. My ex-partner is not. What rights do I have? We touched upon this before.
We did. So I would say, like, look, these are probably some of the hardest of cases because you're technically with the 50-50, and if it extended to legal custody, you're equal. Neither one of you is getting to make the decision here. I would say, again, it's similar to the cases, even if it's a little trickier, is that you follow the doctor's advice, you follow the CDC advice. If you have a parent who's really not doing that, really try as much as you can to document that, because if you do end up denying the non-custodial parent, I mean, it's not even that you're denying the visitation, you're denying a parenting custodial arrangement. So it's a little bit, it's very significant, but if you document all of this and are really able to show, I think if there is an issue and it could lead to a writ being filed, just be prepared for that, and recognize that, like, again, we can't promise that the court won't see what you did as, reasonable, but, I would say, like, again, really try to get as much information as possible from the other side about what measures they are following. If it's very clear that they're not socially distancing and they're completely disregarding the doctor's advice, I would hope that a court would understand that and certainly not find you in contempt. But there's no guarantees in this landscape.
Yeah, absolutely. Okay, now a few more variations on that. This is an important area to address. My ex-partner is dictating what health measures I must be following while the children are with me. I'm not comfortable with this. I want to be able to do my own thing and am entitled to privacy. Thoughts?
I think it's, especially when you're in a domestic abuse situation, there is a concern that you're having this person who historically has used medical decisions as a way to control you and feels entitled to know every single detail about your life. I understand the impulse to say, this person is just really trying to use this pandemic as a way to monitor how I'm taking care of myself and the child, and to question my parenting and to kind of imply that I'm an unfit parent. So I get that. But in this current age, I think it's really important that both parents have an open and honest dialogue about the precautions that they're taking. I don't think it's unreasonable in this context for for the other side, custodial or not, to be saying, what precautions are you taking? Like, are you Lysoling? Are you using gloves? How often are you leaving the house to do errands? How are you doing those errands? I don't think in this particular context, there is there really is always a lower expectation of privacy in these cases. And especially now, I think there needs to be honesty between the parties. And that's kind of what Judge Sunshine is saying, is you need to have a united front and have an open dialogue.
Absolutely. And I mean, what's also important here is that you have to be reasonable. And like we discussed earlier, you can't use this as an opportunity to manipulate or cut off contact. There's a question here. My ex-partner is refusing me substantial contact with the children, even consistent electronic visits.
Yeah, so
you can't catch COVID through a phone or through a video screen. And there's no reason that any parent should be restricting that. They're asking whether they can file in court. What can I do?
Yeah, I think, we've been talking a lot about what the custodial parent's rights are. The non-custodial parent has rights too. And if you're the non-custodial parent, again, the court's not just looking at the custodial, they're also looking at you. Are you being reasonable? And I would say if you're following the social distancing guidelines, and again, you're not taking public transportation, maybe you self-quarantine for 14 days to show good faith. That could be a reason to document, saying, I've been self-quarantined for 14 days. anyone in my household has. This is what I can do to make these exchanges safe. If they're still denying the visitation in that context, I mean, you might even have a case for a writ. I don't know how the courts would honor something like that, but there's certainly an argument to be made there that they're unjustifiably denying you visitation. But at minimum, if they're denying you electronic visitation, I do not think that the court would go over well at all. Like Rachel said, there's just no excuse. So again, document your efforts, get medical documentation, and keep a log of all the attempts that you made, maybe to have FaceTime or Skype or whatever method you're using, and all the times it was denied and the duration. And we're not talking about cases where the children are young and won't sit still and walk away. We're talking about cases where the other side's not picking up or they're affirmatively ending the call early.
Mm-hmm. Absolutely. Okay, there are still so many more questions here. We are really out of time. There are a lot of questions here. Many of them we answered or approached the issue of. There are also some very specific, very case-specific questions where it wouldn't be appropriate to answer them in this forum. But we really do urge you to reach out to Sarah's Voice. We're going to get up the information out there. And while we Jeffrey, keep that on the screen for a minute. And Erin, why don't you just give us some final takeaways?
So first, just with regards to this resource, Sarah's Voice, that's my project. And that number will go to my paralegal, who's also a victim advocate, and she will do an intake with you and then connect you to the attorneys on the project. So that's the second number listed here. I think just the takeaway is, like, despite the fact that there has not been any clear specific guidelines from the court, I think Judge Sunshine's article and the discussion and the dialogue that's going on with the legal community right now, it shows, like, again, the parents are not forgotten. The courts have not forgotten it. This is a really unique and difficult time. And I think we're trying to, as best as possible, come up with a comprehensive response that, again, like, it's custodial parents are in a tough place, but so are the non-custodial parents. And these, I think what we can see, at least what I can see from the questions that have been coming in yesterday and today, is that these are really sensitive, fact-specific questions. And we really do urge you to reach out after the session to our project or to other resources to get advice on your specific case. I mean, we want to hear from you. We want to know what's going on out there. That will help us inform our advice, but we also are there to help guide you through this, because I know that what we cover today is not going to address every single one of your questions, but we're here to clarify things.
Absolutely. And on our website, we have many resources listed with links to them. We also want to thank again our co-sponsors this evening. We appreciate your partnership and for you joining us in this program. So thank you all for joining us this evening. Erin, thank you so much for your wise words, your compassion, your expertise. And please reach out with more questions. We are here for you. Our hotline is available. As I said earlier, all departments of Shalom Task Force are functioning, and we're here to support you. Everyone have a good evening. Stay safe.
Thank you. Good evening.